Hi, my name is Robert Chelle with Chelle Law, and my law firm assists professionals with employment contract issues. Today I'm going to talk about, can an employer require 90 days notice? Well, first you need to determine if you have signed an employment contract or not, and then does that employment contract contain language that states you must give 90 days notice? So when an employee signs an employment contract, there will be a section that's called termination, and then it will list the ways the contract can be terminated. So 4 ways generally a contract can be terminated. Either the agreement just ends after a certain period of time and it's not automatically renewed. It could be terminated through mutual agreement. It can be terminated for cause. So if one of the parties breaches the contract, the other usually has the option to terminate the agreement. Or without cause termination. And so this will be the section that will state whether you have to give 90 days notice or not. So under without cause termination, also called, for no good cause, no good reason. Without cause, I think, is the most common term used. In that section, it will state either party can terminate the agreement at any time for any reason with a certain amount of notice to the other party. So if that notice states you must give 90 days notice to terminate the agreement without cause, then yes, you have to give 90 days notice. Anywhere between 30 to 90 is kind of like an industry standard amount. If you are in a job and you haven't signed an employment contract and you haven't signed some kind of binding letter of intent, if the employer simply asks that you provide 90 days notice, you don't have to give 90 days notice. I mean, in the professional world, if there isn't an employment contract that's been signed and it's not specified how much notice is given, 2 weeks notice is kind of the industry standard as far as what would be a professional amount of time. But if the employment contract states you must give this amount of notice and you don't, you are in breach of contract and you could potentially be sued for a number of things. One, recruitment fees, if they have to get a recruiter to replace you. Lost profits, maybe they paid for licensure, credentialing, privileging, any kind of continuing education. Maybe a signing bonus, relocation assistance. You must give the proper notice if it's in the contract. Some language will be in an employment agreement that even specifically says, if you fail to give the full amount of notice, you owe us this amount of money. And normally that would be whatever the daily rate for the professional is, how much they get paid per day. If you had a 90-day notice requirement and you only gave 30 days, then you'd owe them 60 days of compensation, which for some people can be a substantial amount of money. So yes, the employer can require 90 days notice, but only if it's in the employment contract or if it's a binding letter of intent. Now, binding letters of intent, binding offer letters are very rare. Normally, they are not binding. It would have to have specific language that states this is the entire agreement. These are the terms or conditions of the employment relationship. But just so you know, it is very rare. So normally, if it was a 90 days notice, it would have to be through an actual employment contract that went through all of the terms of the employment relationship. All right. Well, if you have any questions about your employment contract, you can always call my law firm at the phone number listed below in the description. Or you can reach us through our website, chellelaw.com. That's CHELLE law.com. And I appreciate you watching the video. Thanks.